if something, I'm so sorry.
No,
So Professor Jefferson is also from the university that actually organizing this uh, very interesting this unique conference. So Professor Jefferson, when I saw the program and saw your topic, I was very interesting, and of course now I'm eager to listen to you. Professor Jefferson will deliver the keynote in Spanish, or sorry, in Portuguese, and we have a translator here that will translate.
Spanish, yes.
In Spanish, sorry, in Spanish. Uh, because I can see the translator is already like, oh, no. So yeah, I'm so sorry, in Spanish. So, Professor Jefferson, the floor is yours.
Thank you, spasiba. Les hablo en portugués, en español para que me comprendan mejor. Bueno, inicialmente debo hacer un agradecimiento a la Universidad Estatal de Moscú, Lomonósov, y ya lo hizo a la persona del profesor Dugin. Solo le pregunto si tengo que hacer, Natalia, intercalado o continuo. Agradezco también a la profesora Elizaveta Gromova, que hace la presidencia de la mesa, y es un gusto conocer al profesor Daniel Ferreira, mi compatriota brasileño. Bueno, el tema mío es la aplicación de la IA. Usaré este nombre como la abreviación de inteligencia artificial. El tema de la aplicación de la IA en el sistema de justicia de Brasil. Bueno, existe un amplio y acelerado uso de la inteligencia artificial en el sistema de justicia y en los órganos administrativos del gobierno ejecutivo, del poder judicial, del poder legislativo y en lo que llamamos funciones esenciales a la justicia, que son el público ministerio, ministerio público o fiscalía, en la abogacía del Estado y en las funciones de defensoría de los vulnerables y también en otros campos de instituciones paraestatales como los servicios notariales y también en el sector privado de abogacía. Para hablar de sistema de justicia es necesario anticipar algunos acuerdos lingüísticos de hechos y dados. Para mí, sistema de justicia es más amplio que poder judicial. Tenemos en Brasil una estructura federal de 26 estados. Es cerca de, además de la Unión Federal, 5.500 municipios, unidades municipales. Contamos con 6 tipos de justicia. La justicia común de la Unión Federal, una común de cada uno de los estados, una electoral, una laboral y 2 militares, por eso 6. No existe en Brasil una justicia municipal. Tenemos 90 tribunales de apelación o revisión y un tribunal constitucional general en la cúpula en Brasilia. Llevamos políticamente cerca de 40 años viviendo la experiencia democrática más larga del periodo republicano. Tenemos una economía compleja, diversificada y dispersa en todo el territorio nacional, y es multifacético, tiene muchas facetas. Contamos con una población de 213 millones de habitantes, de los cuales 85% vive en las zonas urbanas o de las ciudades. Existe, en la parte judicial, existe una intensa judicialización, Natalia. Nos gusta mucho los procesos judiciales. Por eso tenemos una intensa judicialización debido a diversos factores y estímulos, con alrededor de 83 millones de procesos judiciales en trámite y un flujo anual de cerca de 35 millones de procesos que ingresan nuevos y salen probablemente los viejos. Bueno, hay muchos atascos estructurales con las ejecuciones de tributos. Por eso se imagina que 26,3% millones de procesos son de tributos cobrados judicialmente de las personas que deben tributos y no pagan al Estado. Paso al segundo punto, que es sobre el rendimiento del Poder Judicial. Pero un momento solo, para mi sistema de justicia es más que Poder Judicial. Bueno, el sistema de justicia brasileño procesa un volumen extraordinario de casos a través de estructuras administrativas complejas que muestran tanto una productividad exagerada, notable, con cuellos de botella persistentes. Hay estrangulamientos, cuellos de botella. Los 91 tribunales nacionales emplean 18.000 jueces o magistrados. Emplean 275.000 funcionarios judiciales y un total de 446.000 profesionales. Bueno, por eso, profesora Gromova, I needed the IA. Necesitamos la inteligencia artificial. Además que la inteligencia natural nuestra. Bueno, logros y limitaciones productivas. La productividad judicial brasileña supera con crecimiento o creces de los estándares internacionales. Los magistrados tramitan cada uno un número aproximado de 2.000 casos al año, lo que supone un nivel significativamente superior a otros sistemas judiciales comparados de otras naciones. Perdón, Natalia, cuando huyo del tema. ¿Sí? Sin embargo, las tasas de congestión siguen siendo crecientes y son 70,5% al nivel nacional, y en los tribunales estatales mostrando 74% de congestión en primera instancia. La congestión es los procesos que ingresan y no salen. Eso es un retraso o la congestión. Paso a la parte de asignación de recursos y gastos, que es el tema siguiente. La asignación de recursos y costos. Las operaciones del Poder Judicial consumen en moneda nacional 132.800 millones de reales al año, o en el Producto Interno Bruto 2,38% del gasto público total, o que representa una inversión estatal muy significativa en infraestructura judicial. parte de los gastos son en tecnología para atender a esas necesidades. Las tendencias presupuestarias muestran aumentos o crecientes constantes de millones y millones de dólares y reales en los últimos años. Hay un crecimiento de 6 o 7% al año en los gastos públicos. Bueno, paso a la idea y llego al tema que nos interesa, que es la transformación del proceso judicial electrónico, donde la IA empieza en los últimos años a ganar fuerza. El proceso, la ley de proceso judicial electrónico es del año 2006 y regula la informatización, tiene 19 años, y regula la informatización del proceso judicial electrónico, la informatización, la comunicación del proceso electrónico. Hay un sistema nacional creado por el Consejo de Justicia Nacional que se llama PJE, desarrollado por el Colegio OAB y por el CNJ, que es el Consejo Nacional de Justicia, y abarca 90% del proceso. Hoy, 90% del proceso judicial es electrónico. De los procesos que ingresan hoy día, 99% ya ingresan por el sistema PJE o el sistema electrónico. Y perdón, Natalia, no hay más procesos en papeles. No hay más. Casi no hay. El tercer punto, el sistema opera a través de las varias justicias que hablé. Las 6 justicias que hablé: la justicia común federal, la justicia común de los estados, la justicia electoral y la justicia de trabajo, todas están igualmente integradas en ese sistema judicial procesual electrónico. Avanzo, Natalia, al concepto de sistema de justicia para mí. ¿Qué es sistema de justicia? Sistema de justicia para mí es el conjunto de medios administrativos y judiciales resolutivos o no resolutivos, adjudicativos, prejudiciales, antes judiciales, previos a los juicios judiciales o posteriores al juicio, heterotutelares o autotutelares, estatales, paraestatales o privados. ¿Querés que permita que te localices? ¿Estás ubicada o no? Bueno, ingreso a cuáles son los principales o las principales utilizaciones de la IA en el Poder Judicial y en el sistema de justicia. ¿Cuáles son para mí los puntos más importantes? Son muchas las utilidades y aplicaciones en el Poder Judicial y en el Ministerio Público, en la Defensoría Pública, en la Advocacía del Estado, en la abogacía privada y en otras instituciones. La IA sirve para el análisis y elaboración de documentos y permite la redacción de escritos procesales. 2. La búsqueda avanzada permite la realización y la pesquisa y la búsqueda de las decisiones de los tribunales Además que los libros, todos esos que están atrás de mí, de doctrina, permite también los asistentes jurídicos virtuales y programas y plataformas de IA que actúan como asistentes ofreciendo respuesta a través de prompts a las preguntas jurídicas que hacemos. También y especialmente la automatización de documentos y la clasificación de esos documentos, tanto en el Poder Judicial, en el Ministerio Fiscal, en la Abogacía del Estado, en la Abogacía Privada, en la Defensoría Pública. También análisis predictiva basándose ampliamente en los datos anteriores para ofrecer las respuestas posibles a los problemas que esperamos enfrentar. Además, la gestión de los casos más importantes, automatizando el último punto, la tramitación judicial por IA. Un ejemplo está en negrito, en negro, el sistema Víctor del Supremo Tribunal Federal que usa la IA para clasificar los procesos. Paso, Natalia, al punto sobre el uso de IA en cada uno de los sistemas. De esos campos todos. El Poder Judicial es el más importante, claro, pero en él, para que tengan una idea del Poder Judicial y las 6 justicias, el Consejo CNJ ha catalogado solo en el año 2025 140 proyectos de IA en los 91 tribunales, con uso de tecnología para busca principalmente de eficiencia. Este es el mote y el reto, el desafío nuestro. Por tanto, hay cerca de 140 estudios y programas de IA particulares. Y como ha dicho el profesor Ian Burlay, hay un aspecto muy curioso. Esos sistemas son creados dentro de los tribunales y no fuera, con códigos abiertos. Espero que consiga traducir. Paso a la fiscalía. La fiscalía, como la de ustedes, es el Ministerio Público nuestro. ¿Y en qué utilizan? En generación automática de resúmenes de procesos, en predicciones de penas para los crímenes. En las defensorías también la utilización es principalmente para la elaboración de decisiones y de manifestaciones de los defensores públicos. Los defensores públicos en Brasil trabajan para ofrecer defensa y orientación jurídica a personas que no tienen capacidad de pago de un abogado y así buscan el trabajo de los defensores. Hay una Defensoría Pública Nacional o federal y hay 27 defensorías en los estados federales. ¿Para qué sirve la IA a los abogados? Hay cerca de 1.400.000 abogados inscritos en colegios en Brasil. El colegio nuestro se llama Abogacía, Orden de los Abogados de la Unión. La utilización en abogacía privada y en abogacía pública es para la elaboración de papeles y las manifestaciones todas de los abogados en todas las etapas del proceso. Así como el juez hace la sentencia con IA a veces, o utiliza la IA para responder sus preguntas, nosotros, abogados públicos o abogados privados, también hacemos eso. Paso al punto de las estructuras federales y después a un análisis final. Como somos exagerados y tenemos 26 estados, el Consejo Nacional de Justicia intenta dar una estructura uniforme para la utilización de la IA por los tribunales nacionales. Y hay una resolución de ese año que establece directrices de seguridad, transparencia y protección de datos personales para que la IA entre nosotros en las funciones judiciales, en el Poder Judicial, tenga transparencia y protección a los datos todos. Y ahora sí paso, Natalia, al análisis final con ventajas, con algunos impactos, con retos o desafíos actuales y caminos y tendencias. Y profesora Elisabetta Gromova, me aproximo del final, de the end. Las ventajas y la ventaja principal para nosotros, claro, es la productividad, el desarrollo tecnológico y principalmente la eficiencia de los sistemas judiciales para atender los 83 millones de procesos que tenemos. Los impactos han sido notados especialmente en los últimos años. Tuvimos ya 86 millones de procesos y tenemos una tendencia a queda. Por eso se imagina por estudios estadísticos que el número de procesos debe declinar con el uso del proceso electrónico y de la IA por los jueces y por todo el sistema de justicia. Los desafíos actuales principales son, porque Brasil es como Argentina y Rusia y todo, un país muy desigual y el poder judicial en cada lugar es también muy desequilibrado. Algunos tienen alta inversión y alta tecnología y otros no tienen los mismos niveles. Por eso el desequilibrio regional y federal es el principal reto o desafío. Y los caminos y tendencias, nos parece, son, para finalizar, la superación de las desigualdades, las inversiones en todo este sistema, que están también los notarios, que están afuera del sistema judicial, de las cámaras de arbitraje privada, que también integran los sistemas, en los sistemas electrónicos de resolución que surgen en Brasil cada vez más. Y con eso, y con la aparición de mi colega Daniel, yo concluyo con un agradecimiento especial a la universidad, imaginando que tomé una parte del tiempo de ustedes, pero con grande gusto para mí, por lo menos. Y un saludo y agradecimientos también a Natalia, que sufrió muchísimo. Por suerte está grabado eso. Gracias, profesora Elisabetta Gromova. Thank you, spasiba.
Gracias, muito obrigada. Thank you so much for this very interesting keynote. I knew a lot of information about the Brazil, how artificial intelligence works in Brazil. And I'm curious, how do you think? I know this question may be, people may be asking it all the time, but still my question is, what is your opinion? Will artificial intelligence replace the judges in Brazil?
Socorro, Daniel. É uma pergunta?
Ela perguntou se você acha que que a inteligência artificial vai substituir os juízes no Brasil algum dia.
Yes.
I think it's better to use English
Yes or not?
because I don't speak.
Responde em espanhol para ela.
Sí. Sí y no. El trabajo humano creemos que no desaparecerá. Hay estudios desde los años 60 que parte de las tareas serán automatizadas, pero algunos autores imaginan hoy que la masa numerosa de procesos va a desaparecer y quedará una pequeña parte compleja y más difícil que los programas hoy existentes no resolverán totalmente, pero los más optimistas imaginan que sí, que casi todas las tareas de las funciones estas nuestras, yo soy abogado del Estado y de los defensores y del Ministerio Fiscal, y otras desaparecerán.
Do I need to translate this, or did you guys get it?
No.
You got it? No. He said basically yes and no at the same time, that in some cases, of course, the number of lawsuits will reduce because of AI, but some jobs are for humans, so he doesn't think that in the current state that will change, not for long at least. So what I hear, in my opinion, here from the judges in Brazil is that the number of justice will reduce because of AI. So people there, because in Brazil, to be appointed as a judge, you're not appointed. Actually, you do a test, a difficult test, public contest. So people that study for that, they strive a lot for years to pass the judge test. And the number of spots for becoming a judge are reducing. So people are like getting more, like they don't even know if they're gonna keep investing in that or not. But so it's becoming harder to become a judge in Brazil. I think that's one of the effects of AI. So that's what he said. Basically, he also said that AI will help the public attorneys like himself, but it will not substitute entirely.
Thank you so much, dear Professor Jefferson, for this amazing keynote. I guess I will start learning Spanish.
I think Natalia raised the hand there.
Yeah.
Yeah. I have a question. So, which GPT model do you use in your product, Victor? Was it like an open source solution or a custom trained model? Or
Sorry, can you repeat that because it failed a little bit?
Mm-hmm. So which GPT model, which LLM did you use in your project, Victor? Was it like an open source solution, something from like ChatGPT or Perplexity, or was it a custom trained model, so something crafted in Brazil?
Qual modelo que você usou de AI, chat GPT ou algum produto feito de maneira customizada aqui no Brasil, alguma coisa open source, né, com código aberto, etc.
Los tribunales utilizan esos sistemas internacionales, pero
The courts utilize the international models, the international systems,
pero el desarrollo de los programas, todos de los tribunales, son con código abierto.
but all the systems that are utilizing the tribunals are with open source code. So,
But Las otras funciones, Daniel, los abogados, especialmente que utilizan los programas comprados que llamamos de prateleira, ¿no? Los programas Gemini, ChatGPT, Perplexity y todos los chinos. Yo tengo en mi teléfono, por ejemplo, solo para hablar de mí solo.
But all the public attorneys, they utilize the systems bought and the already ready ones, ready to go, like ChatGPT, Gemini, and so on and so forth. He has in his cell phone one of those, for example.
Yes, Perplexity here, ChatGPT, DeepSeek, Chinese,
Yeah, DeepSeek,
and SciSpace, and many programs, commercials, free or no free, pagos ou não pagos.
Mas são os próprios, a AGU que paga, por exemplo, para vocês? Não, ou é pessoalmente?
No, la Abogacía del Estado, AGU, tiene en nuestro sistema interno un desarrollado por el Sapiens, que es el sistema interno de Abogacía del Estado. Aí não sei como te explicaria, mas como abogado eu compro o que quero, pero se utilizo em mi computadora, eu utilizo del órgano estatal, que en general es desarrollado por el órgano estatal y de código abierto, pero es cerrado a los funcionarios públicos, empleados públicos.
Okay, so personally, he utilized his own, he pays for it personally for ChatGPT, DeepSeek, or whatever. And when he is using at a state attorney, he must utilize the ones that are open source, paid by the government. So he's used the official ones as when working as a state attorney. So that's what happens, And so you guys know that the tribunals, the courts here, the state courts and the federal courts, they all have their own systems, So it's kind of hard, for example, to find specific lawsuits because each one has its different search engine, for example. So each state develop its federal area division, develops its own programs and systems and so on. So, it should be unified when it's not. So I can only imagine a Russian trying to find jurisprudence here in Brazil in the state courts, each one with different search engines. So it's not that easy. That should be improved in Brazil. I think in Russia it's even worse. I cannot find jurisprudence, case law in Russia, not even if I wanted to. So, I think if we want to talk about the BRICS, about harmonizing, about we should improve that and work together.
Thank you, Lord, for your answer. Muchas gracias por su respuesta. Sí.
Gracias.
Thank you so much again, Professor Jefferson. It was very interesting to listen to you. And now, so we just discussed very interesting and crucial issues on the use of AI in the justice. But because our panel is also devoted to the digitalization in general, now we will talk about the games. Everyone loves playing games, and digitalization allows us to play many games, online games, and it is the industry. And of course, there are many issues arising from the games. And of course, we can also talk about the dispute resolution. And actually, it is what we will now listen from our dear friend, Professor Daniel Brantes Ferreira. He will talk about game genres and dispute resolution. Professor Ferreira also represents Brazil. So, Professor Ferreira, I can see your PPT. If you could make it, yeah. So the floor is yours.
It's done. Speaking Portuguese, just a quick second. Professor Jefferson, foi um prazer te conhecer. Parabéns pela palestra e conte comigo. Depois eu entro em contato contigo para a gente tomar um café aqui em Brasília, se se tiver disponível, sempre um prazer. Como recém-chegado a Brasília, fazer amigos, e principalmente aqui na Rússia, é sempre importante. Well, first of all, I'd like to thank Professor Elizaveta and everyone from the Moscow State University. I had the opportunity to be there 3 months ago, and I loved every second. Great university, and you guys offered me medavik, my favorite dessert. So you live in my heart. And of course, this lecture now, I'm going to speak about games. I've always been a nerd, let's put it that way. Since the early days, I've played Atari, in the 80s, and I followed all the evolution of the games since present time. So in studying the topic, and of course, my main topic here is dispute resolution. It's what I've been researching for many years now. I'm the editor-in-chief of the Brazilian Journal of Alternative Dispute Resolution, and also with Professor Elizaveta of the International Journal of Law and Changing World. So I'm between dispute resolution and law and new technologies. So that's the topic here that we tried to intertwine. And when I say we, it's because this is a current paper being reviewed by a journal, and I've written that with Professor Elizaveta, which is my digital technology style, let's put it that way. So by researching games, we found a controversial topic, which is the game genres. So when we talk about games, each game is labeled as one genre, and not more than that. They also have subgenres. So you talk about a first-person shooting game, you will have a different subgenre. If you talk about sandbox game, you also have a subgenre. But of course, this primary genre classification varies a lot, and it's criticized by literature. So when we talk about genres, for example, these famous games, they are also they are always they are the most played games currently. For Fortnite, we can talk about Minecraft here, Roblox, Mario Kart, it's an adventure game, sports, Call of Duty, so World of Warcraft. So these are just examples of game jams. So what World of Warcraft is MMORPG, massive multiplayer role-playing game. So Roblox and Minecraft are sandboxes game where you find like an empty map and you can build, and of course the games monetize their products. And Call of Duty, first-person shooting, Fortnite, we're talking about Battle Royale here. So many genres, but they mainly come from the industry. So there are some websites, for example, Steam, where the gamers actually label the genres of the game. So it's you never find it like a specific that this is the genre. Let's put it this is the genre of this game. It can vary and it can be modified through time. So when we talk about games here, before playing a game, before playing, for example, a video game, you must read and accept the terms of use, the end user license agreement, the EULA. So, but you know what? I used to say that this is one of the biggest lies in the world. I have read and accept. Okay, you accept. That's clear for me. You just click there in a click wrap page. But have you read it? That's the question. And literature, it affirms, like 100% of the paper affirms that only 2% of the people actually read it the same way. So usually you just want to play, you just want to install the software and play it right away, but you don't actually read the terms of use. And case law, jurisprudence, especially American jurisprudence, when you accept it, it's done. So you are attached to those terms when it comes to any issues that may arise, many disputes that may actually arise. And my main topic of research is when it comes to these kinds of contracts is to look at the dispute resolution clause. So if I have any problems here while playing this game, if I buy a product in the game and that they don't deliver what I had expected, for example, if I got my account banished, so how can I deal with that? Can I go to justice? Can I go to arbitration? Where would I go? So a good dispute resolution clause actually reduce the risk perception of the consumer. But if you don't read it, you have no idea about the risks you are taking before installing that game. Just so you have one perspective, when you're playing, for example, an Xbox game, before playing the game, you have to read and accept 5 different legal documents. PlayStation 5, 3. So just to play a game, you have to read a bunch of legal documents with technicalities that usually no one will actually read. So most users here accept and don't read the terms of use. And in some games, it's even difficult to find the terms of use. In this paper, in some games, I didn't even find the terms of use. So, and that's difficult. Even the industry make it hard for the consumer to find and actually to read the terms of use. But when we talk about dispute resolution clauses in games, regardless of the game genre, of the type of the game, they are basically standard. So in most of the top 20 played games currently, I found this standardization and this scenario. So they usually, basically for US consumers, okay, they usually talk about a 30 or 6-day mandatory informal negotiation period, which means that before going to arbitration or to the court, to have to negotiate with the company, the publisher of the game. And of course, after that, you can go to binding arbitration, and they all bring a class action waiver, which means you cannot sue the company with other players in a class action, which happens a lot in the US. And you also have a 30-day opt-out window, which means that just after you stone the game, you accept the terms of use, you have 30 days to opt out from the arbitration clause, which means that you had the opportunity to go out from the arbitration and go to the courts. But if you don't read the terms of use, you have no idea about this opt-out window. And of course, there are slight variations between games, but this is the scenario that you find in the main games, and they don't vary according to the game genres. So our thesis here is that dispute resolution clauses, this should be adequate to the game genre. So for example, MMORPG, they have a massive virtual population interacting in the game. And the biggest problems that I found in jurisprudence, in case law, is cheating and botting and virtual items and bans. So people buy virtual items or they exchange virtual items when they couldn't, and account bans. And Brazilian jurisprudence, for example, has already declared that your avatar adheres to your personality, so it's part of your personality, right? So it leads to moral damage if you are banned without proper reason. So this is just one style of game. So if you go to first-person shooting games, gambling with items, copywriting clones, sports games, you have against the players, right, likeness rights, loot box, so if all the game genres, they have specific problems here arising. So, for example, when we talk, this was funny because I found papers about this, but when you talk about virtual reality and augmented reality games, one of the main problems here was headset injuries. So people are actually wearing those goggles, those virtual reality goggles, and they get injured in the back or they fall or something like that. So that's very specific about virtual reality. So our thesis here is that the dispute resolution clauses should be customized according to the game genre. So the industry should read and should have this capability of analyze the main issues arising and then drafting the dispute resolution clauses according to the game changer. That would optimize the disputes, and that would be much more comfortable and friendly, of course, for the players and for the users of the games. So what are my main recommendations? And of course, this topic goes deeper and deeper. The discussion about game genres is huge in literature. And of course, the discussion about the drafting of dispute resolution clauses, about regionalization, because most of the dispute resolution clauses, they mainly talk about the US, they focus in the US consumers, and they kind of forget the other regions. So we analyzed a lot of data in this paper to draft recommendations at the end. So what's the thesis here? So first, readability and accessibility of the dispute resolution clause. I found, for example, one game that speaks the language of the users, like it makes a Q&A, questions and answers. For example, what the heck is arbitration? So it explains what arbitration is for the gamer. So what I didn't like to is because you had mainly mandatory negotiation before arbitration, but most of the terms of use forgot about mediation, would be an important step when we talk about multi-tiered dispute resolution clause or hybrid clauses, for example. So, the industry should think a little bit more about mediation. And, another issue here is to keep the dispute resolution clauses within the main terms of use and not in secondary sources, because you find the main terms of use always with a link to secondary sources like private policies and other documents, which makes it even harder for the users to access all the documents and read them. And, to update, of course, regularly the dispute resolution clauses. For example, in most of the games I found for European users, the terms of use directing the users to the ODR EU platform, the online dispute resolution platform of the European Union, which was discontinued now in July of 2025. So, and they're still putting that in the terms of use, which shows that they don't really care that much in updating regularly the dispute resolution clauses. And of course, customize the clauses by jurisdictions, which it's very poor in the terms of use. For the US users, okay, perfect. But Brazilian users, Russian users, they have a huge market here, the game industry, but they don't really take care about seeing what our domestic jurisdictions really how they deal with consumer disputes, because at the end of the day, these are consumer disputes. And of course, at the end of the day, the main thesis here is to draft tailored clauses based on the primary game genre. That looking at the disputes from the genre would enhance the applicability of the dispute resolution clause, and as I said, it would turn it in more friendly for the gamers. So to end here with a gaming quote by Half-Life 2, the game, the right man in the wrong place can make all the difference in the world. So whenever you are in game, you are in society, try to analyze, to look at things differently, in a different perspective. And I really think that reading the terms of use and getting contact with the publisher of the game could make a difference and could reduce your risk while buying stuff in a game, for example. Spasiba, thank you, and of course, I'm here for questions.
Thank you so much, dear Professor Daniel. As usual, it was awesome keynote. And very interesting. The topic is highly relevant. And my question, so maybe we have many listeners actually here, so if you have questions, you can always write it down in the chat.
Si quieres, puede hacer preguntas en español también, en portugués, en English, and French.
and Russian.
Russian? Давай,
I will translate.
давай.
But my question is about you recommended to increase readability, and we all know that I know my question is actually, is that possible to increase this readability? Because what we do is, like just agreeing with everything. So when you said about it, I started to think, how can we increase the readability? So maybe we can use some technology that will, checking if if the user, checked all the text or not. So this is a really interesting question to discuss. Can you share some views on the topic?
Well, if, for example, with current, like Professor Jefferson was talking about AI, but with current technology, if I'm the consumer, I get the terms of use and put on ChatGPT, for example, and ask, what are the risks here? What's the dispute resolution clause? Can you clarify that so you can use technology in your favor to make it easier before accepting it? And there are papers about like a scanner who reads it and something like that who helps. But most consumers, they just won't use the technology for that. They just don't care about the terms of use. For example, as a Brazilian consumer, I know that arbitration in these cases will not be applied if I go to the courts. So I'm very safe as a Brazilian consumer. But if the company only has is only established overseas, so I'll have to start a cross-border dispute. So that will make harder for me to enforce any Brazilian justice decision. So technology can definitely help to read, but the company should do a better job by writing the terms of use, not in legal terms, but in a user-friendly terms. We're talking about gamers. We're talking about minors accepting terms of use, for example, which they holding capacity, for example, to accept an arbitration clause. And there you go, they're accepting an arbitration agreement. So there are many questions that actually arise from this, but definitely technology can be really helpful, But for example, ChatGPT, if you ask ChatGPT, the terms of use of this game, he'll probably direct you to outdated terms of use or to the wrong terms of use. So it's safer to copy and paste the terms of use and put in ChatGPT, for example, and ask for it to analyze it. I would recommend that if you really want to, at least someone read it to you before you accept it.
Thank you so much, dear Professor Daniel, for your answer, for your thoughts. And now I think it is my turn to deliver a keynote. So today I'm moderating the panel, and also organizers gave me the honor to deliver the keynote. And as our topic for today is both artificial intelligence and digitalization, my keynote will touch both of these topics. So let me firstly try to share my screen.
Daniel? Así.
Can you see it?
Yeah, perfectly.
Yeah. Thank you so much. I know how precious your time is, so I will try to be as brief as I can. So we just discussed how technologies are crucial nowadays, and how we are interested in technologies, and we are interested in artificial intelligence. We are interested in other digital technologies. My keynote will be mostly focused on the artificial intelligence. We know that artificial intelligence is, I will not show, sorry, I need to make it full screen. we know how artificial intelligence is important nowadays, and that we still need to find proper regulation for artificial intelligence. And we know that many countries they are trying to find this regulation, but regretfully, we don't know what will be the most efficient approach. And at the same time, we can't wait, because technologies and artificial intelligence specifically, they are developing so fast. So we are already discussing ChatGPT and other intelligent chatbots a lot. Professor Jefferson talked a lot about the use of AI in the justice. So artificial intelligence is everywhere, but still law doesn't know how to deal with it. And I will now quote Elon Musk, that said that it is a famous quote. He said that with the artificial intelligence, we actually summoning the demon, which is actually the truth, because artificial intelligence has unlimited potential, but it also brings so many threats to human rights, to our lives, that we really need efficient regulation to control the technology, because no one wants Terminator movie to become a reality. And one of the modern approaches nowadays was the approach that could help law to react, because we understand that law should react. Law must catch up with the rapidly evolving legal relations. So we need to find this decision, this way to solve the problem. Because on the one hand, we are interested in the development of the technology. We are interested in artificial intelligence. It is impossible for us not to be interested. On the other hand, we have a regulation that already exists. And sometimes we need to find the compromise between current regulation and the necessity to develop artificial intelligence. And I want to make some example for you. We know how crucial is the use of artificial intelligence for healthcare system. There are many artificial intelligence-based devices aimed to improve the healthcare system, and I want to make an example of two. One is very important tool. It is called Botkin artificial intelligence. Botkin was famous Russian surgeon, and now in Moscow there is a hospital named after the surgeon. So there is an there is a device called, actually a program, AI-based program, Botkin AI. What does Botkin AI do? It helps to detect cancer at early stages. We all know how it is important to be able to detect cancer at early stages. So the device is very helpful. Another example is Care Mentor AI. So would be awesome if we could just, implement these technologies into the healthcare system, because the technology literally can save lives. However, we have very strict regulatory requirements. For example, in Russia, if we want AI-based technology to become official medical technology, we need to pass a very strict registration procedure. It takes time, it takes money to make a device, AI-based device, it's official medical device used in healthcare system. So the problem is, if we want to develop technology, should we follow regulatory requirements, or we need to do something different? To answer this question and other questions related to the regulation, to the search of the proper regulation for artificial intelligence, regulators across the globe started to use what's so-called regulatory sandboxes. I know that you may be familiar, I'm mostly sure that you're familiar with this tool. It is incredibly popular nowadays, and many countries use regulatory sandboxes. In Russia, we do not call it regulatory sandboxes, we call it experimental legal regime. And nowadays, there are many thematic sandboxes. Thematic sandboxes means sandboxes that aim to development of some certain specific technology. So we have AI regulatory sandbox. For example, one we have in Russia, and I will talk about this experiment a bit later. So why are we interested in regulatory sandboxes for artificial intelligence? Sandbox as an experimental regime will help us to find proper regulation for artificial intelligence. But how? We temporarily apply regulatory relaxations. And as a result, we can check if the fact that we do not use current regulation, if it is good. So let's think of something new, some better regulation, or actually existing regulation is okay, it is useful, so we can just stay with the same regulation or maybe evolve it a little bit. So this is actually, that is why actually regulatory sandboxes has amazing potential, and that is why these regimes are very successful, are very popular across the globe. Here in the slide, you can check the definitions of regulatory sandboxes. I will not read everything, but so this is just for us to understand what the regulatory sandbox is. And here you can see the map that shows the spread of regulatory sandboxes. So as I told you, the tool is extremely popular and many countries uses it. And actually the map is a little bit outdated because countries launching sandboxes day by day. So that is why, the map is maybe a bit outdated, but still we can see how it is widespread, and you can see the amount of investments that business got because of the use of regulatory sandboxes. So before I talked only good things about regulatory sandboxes because truly I'm a fan. This is my research area. I love regulatory sandboxes. I have myself and Professor Daniel, we have papers on the topic. We do research here a lot. But so, and we can see that actually regulatory sandboxes are of great use and of great interest of modern countries and modern regulators. But I would ask this question because of the human rights. If regulatory sandboxes and human rights are friends or not? So before, of course, all that I showed you was that regulatory sandboxes, of course, are the friends to human rights. Why? Because regulatory sandbox gives us an opportunity to make an experiment, to check the technology and to find best regulation for this technology. This is very important. What is more, this experiment is, it is called like, this experiment is in low-risk environment. So it is control experiment. State always controls it, which is actually very good for businesses and for consumers, because the state will always prevent making harm to the consumers, on the one hand. On the other hand, due to the fact that regulatory sandbox offers some relaxations, sometimes made the critiques of this tool to say that actually regulatory sandbox is just a way to bypass consumers' law. And later I will show you why. So you can see that despite the advantages, this tool actually is not perfect. And let's check Russian example. In Russia, we had we had regulatory sandboxes aimed at testing artificial intelligence to implement this technology into the healthcare system. This experiment was in Moscow. We know that if we want to test artificial intelligence, if we want to develop the technology, if we want to develop artificial intelligence, we need to upload as many data as we can. But if we want to use artificial intelligence in healthcare system, we understand that we are talking about medical data, and medical data is a special category of the data, and we can't, just share this data without consent of the patients and so on. On the other hand, we are interested in the use of in the implementation of the artificial intelligence into the healthcare system. So, Russian government decided to make this experiment, and in trying to bypass the legislation on the personal data protection, of course, in a legal way. They set up this experiment and said that for this sandbox, personal data, personal medical data can be used, but to protect the rights of the patients, of course, we need to depersonalize the data. So all data that will be used for to train artificial intelligence will be depersonalized. And actually, it was perfect idea. If data are depersonalized, it means that we will not violate any human rights. But it would be if we lived in the perfect world. Regretfully, it is not that, and we actually didn't have proper procedure for depersonalization. For example, in the United States, there is a standard, a technical standard that shows that contains the procedure of depersonalization. Nothing like that was in Russia when we started this experiment. That is why when the residents of the Moscow found out that now their data will be used to test artificial intelligence, they said, you are violating our constitutional rights. And that is why it was a proposal to set up a moratorium for this experiment, just because of the lack of the proper procedure. So not because the regulatory sandbox is bad, but because we didn't prepare the procedure. Another issue here, we know that testing within the regulatory sandbox, testing is in real life conditions, in real life market with real consumers. But the problem is that, regretfully, that consumers are crucial here, because we basically test the technology on these people. But do we protect them properly? If we check Russian legislation, and not just Russian legislation, because we made a research check in BRICS countries, so we could see that actually regulators in BRICS countries do not provide efficient mechanisms for protection of consumers. So what is the problem? For example, in Russia, the problem is that we don't ask for a consent. We actually saying, our law actually saying, if you start relations with the participant of experimental legal regime, it means that you're automatically agreed to be the part of the experiment. How will consumer know that he is an experiment? For this, law tells us, so we made an announcement in the website of the government of Russian Federation. That is why consumer must know that actually it is an experiment. And to compare with other countries like Australia, Singapore, Canada, they always ask for consent of consumers to be participant of the regulatory sandbox, and what is more, they asking for, written consent. What else? Other countries, for example, Australia. Australia is very progressive with its regulatory sandbox. It offers additional compensations for consumers to whom the harm was made within the experimentations. So they actually offer the insurance, which is, of course, a great and a very good, efficient measure to protect consumers. I know that I think I'm a lack of time already. So all I wanted to share in my slides and within my keynote that nowadays we have very useful and potential tool, regulatory sandbox. It is, as I told you, it is being used across the globe. And there are each country uses its own national model of regulatory sandbox. And the problems here is not in the tool itself, because tool, as I told you, is very good. It has the potential. But the problem is how each country how each country design the national model of the regulatory sandbox. So I showed you Russian example, and I demonstrated that, regretfully, in this case, our law is not perfect. And of course, nowadays, the task of the goal of every scholar that is interested, that is the fan of regulatory sandbox, to offer some improvements of the regulation of regulatory sandboxes. And this is actually what I'm currently doing. So thank you so much, dear listeners, dear speakers, for your attention. I finished my keynote, and if you have some questions, maybe in any language, I will be glad to answer. If no, we have. So if no, I'm becoming a moderator again. And so what I want to say today, we have very interesting discussion. We have a very interesting panel because the topics that we discussed are crucial and highly relevant. And I'm sure we all learned a lot from each other today. Actually, I did. And of course, Professor Jefferson and Professor Daniel, thank you so much for your time, for your great presentations, for your keynotes. I hope we will cooperate in the future. And of course, thanks to our dear translator, dear Natalia. Thank you for your efforts. Thanks to Students Club of Moscow State University for this brilliant initiative. Thanks to everyone.
Thank you. Hope to see you again. I guess goodbye for now.
Hope to see you again too. Bye-bye.
Iba, obrigado.
Record.